Hello everyone. We will talk about the rights and conditions of membership in a labor organization. Firstly, no arbitrary or excessive initiation fee shall be required of the members of a legitimate labor organization, nor shall arbitrary, excessive, or oppressive fine and forfeiture be imposed. This means that if someone wants to be a member of a labor organization, he or she should not pay any amount or whatsoever in order to be a member of that organization. Secondly, excessive or oppressive fine and forfeiture. This means if you are a member of a labor organization and you committed any wrongdoings or misconduct, you should not be fined arbitrarily. It should not be based on your employer's personal whims. Your fine should be justified. Second, the members shall be entitled to full and detailed reports from their officers and representatives of all financial transactions as provided for in the Constitution and bylaws of the organization. Essentially, this means is that all members should know the details of all financial transactions involving the members. This should be reported to them by the higher-ups, the representatives, or the officers.
Letter C talks about the election in labor union, and all members has the right to elect their officers and likewise run as officer. Now, the law imposes only one single qualification to run for office in labor organization, and that you must be a member with good standing. A member with good standing is a member who has fulfilled the requirements of membership in the union and was neither voluntarily withdrawn nor suspended or expelled after appropriate proceeding and consistent with the lawful provisions of the union and its bylaws. Now, the law prohibits for adding any other qualification aside from being a member with good standing. And be that as it may, while it prohibits, the law provides for disqualification. Letter D is actually understandable. It provides the right of all members to participate in a question of major policy that affects the membership of the organization, and it is done through a secret ballot.
Letter E. No labor organization shall knowingly admit as members or continue in membership any individual who belongs to a subversive organization or who is engaged directly or indirectly in any subversive activity. It says that no labor organization shall qualify a candidate that has engaged or had been engaged on subversive organization or subversive activities, even if it is direct or indirect. Letter F. No person has been convicted of a crime involving moral turpitude shall be eligible for election as a union officer or for appointment to any position in the union. It says that no candidate or officer must have a crime record involving moral turpitude.
Article 250-241, Rights and Conditions of Membership in a Labor Organization. Letter G. No officer, agent, or member of a labor organization shall collect any fees, dues, or other contributions in its behalf or make any disbursement of its money or funds unless he is duly authorized pursuant to its constitution and bylaws. So the explanation is, it is clear that no person can and must collect or a member of organization of fees no matter what the reasons are, since it is needed to be authorized by the law. But on the other hand, they must and have the right if it is being allowed by the law and constitution. If they are collecting fees without the authorized by law, it is an illegal act and it is punishable by the law. According to Resolution Amending Rules 141, Legal Fees of the Rules of Court, Section 3, persons authorized to collect legal fees, except as otherwise provided in this rule. The officers and persons herein after mentioned, together with their assistant and deputies, may demand, receive, and take the several fees hereinafter mentioned and allowed for any business by them respectively done by the virtue of their several offices, and no more. Next is the letter H. Every payment of fees, dues, or other contributions by a member shall be evidenced by a receipt signed by the officer or agent making the collection and entered into the record of the organization to be kept and maintained for the purpose. The explanation is, the provision states that a payment of fees and or contributions by all the members should have a receipt for a future reference to avoid illegal activities and to maintain a just action by all the members. Since, if there is no receipt that have been issued, wrongful act can be easily committed and exploited by unjust individuals, especially those who have poisoned mind. Thank you.
Under Article 250 of the Labor Code of the Philippines, one of the rights and conditions of membership in a labor organization is that the funds of the organization cannot be used in other purposes, except what is in the organization's constitution and if it is agreed by the members during the general meeting. For example, we have X, a treasurer in a semi-private company. He was terminated because he used one part of the fund to buy a parcel of land for the president's expansion of his home office without informing the member. The expansion of such is not included in the organization's constitution. If the expansion is needed, it should be in the office of the organization or for the benefit of the organization. It is clear that the land is for self-interest of the president and the expansion does not have a purpose of the general welfare of the organization. Therefore, X was terminated. Next is letter J, which states that every income or revenue of the organization shall be evidenced by a record showing its source, and every expenditure of its fund shall be evidenced by a receipt from the person to whom the payment is made. That includes the name of the receiver of the payment, date, place, and the purpose of the payment. For example, the deed of sale of the land that X bought, which is submitted in the company, is a valid evidence since it includes the name of the receiver of the payment, date, and the place where the transaction was made. Up next will be letter K.
Moving on to letter K, this talks about officers of any labor organization that they shall not be paid for any compensation but only salaries and expenses because of their positions as provided for in its constitution and by laws, and therefore every minutes of meetings and list of participants and ballot cast shall be subject to inspection by the Secretary of Labor, and if there are irregularities to the approval of resolutions shall be ground for impeachment. And for letter L, it talks about the responsible of a treasurer or any officer who deals with the account for any labor organization, that they shall render to the organizations and its members a correct account of such money paid and received by him or her since the last date when he or she rendered account, bonds, securities, or properties of the organization charged to his or her custody, and rendering of account shall be made for at least once a year within 30 days after the close of its fiscal year, and also at other times, and just upon vacating his or her office, and therefore the account must be duly audited and verified by affidavit, and a copy thereof shall be furnished the Secretary of Labor.
Good afternoon, everyone. Today we're going to talk about the letter M of the Article 250, Rights and Conditions of Membership of Labor Organizations. So letter M states that the books of accounts and records of the financial activities of any labor organizations shall be open to inspection by any officer or member thereof during office hours. So financial activities is very crucial for any organizations, including labor organizations. Therefore, it is necessary for every member to have the knowledge of every changes or every updates regarding it. But it is to be noted that it should be only done during office hours to avoid unwanted and unwarranted activities. For example, a member of an organization wants to get information or to access information about the financial activities of the organization, such as their expenditure, their funds, or their purchases. She has the right to see the books of accounts records records to examine if the information that is written there is correct or valid, but it is to be noted that this activity should only be done during office hours. Article 250, which mainly speaks of three requisites that must be followed by the labor organization. The first one is the authorization by written resolution of the majority of all members on a general membership meeting duly called for the purpose. The second one is the secretary's record of the minutes of the meeting, and the third one is the individual written authorization for the employee concerned. So, an example of this is the ABS-CBN Supervisors Employees Union Members versus ABS-CBN Broadcasting Corporation, wherein the three requisites of the Article 250, paragraph N were met. Um, the first one is that they held a general meeting for the 10% check-off. The second one is their Secretary Maria Carmina M. Munoz noted the minutes of the meeting, which is approved by the President Herbert Rivera. And the third one is that 85 of the employees or the members of the union executed individual written authorizations for the 10% check-off. Therefore, the 10% check-off is valid because the three requisites of the Article 250, paragraph M were met.
There is a need of an authorization letter signed by an employee containing the amount, purpose, and beneficiary of deduction in cases of special assessments. Moreover, it is the duty of the organization to inform its members about the provisions, rights, and conditions under the existing labor laws. It is also the obligation of the organization to assess the dues, to finance the labor relations seminars and other related activities. Any violation of the aforementioned rights and conditions shall be a ground for termination or cancellation and expulsion of union and officers within the said organization.
This issue is not current, but it relates to the Article 250, which is the member rights and condition of membership in labor organization. This case is entitled Edgar Y. Tevez versus Comelec and Herminio Tevez. The petitioner was a candidate for the position of representative of the 3rd Legislative District of Negros Oriental during the election of 2007. Herminio Tepes filed a petition to disqualify Edgar Tevez for having a criminal record that involves moral turpitude, which carries the accessory penalty of perpetual disqualification from public office. Since our focus is on Article 250, the issue of the case is whether or not the petitioner was convicted of a crime involving moral turpitude should be resolved taking into consideration the findings of the Supreme Court in GR number 1541A2, which is another case. The court resolved the issue of whether or not petitioner's violation of Section 3 RA number 319 involves moral turpitude. The court defines the moral turpitude. Moral turpitude has been defined as everything which is done contrary to justice, modesty, or good morals, an act of baseness, vileness, or depravity in this which a man owes his fellow men or to society in general. The court's ruling is that um, while the possession of business and pecuniary interest in a cockpit license by the local government unit is expressly prohibited by the present LGC. However, its illegality does not mean that the violation thereof necessarily involves moral turpitude. or make such possession of interest inherently immoral. Wherefore, the petition is granted. The asyled resolution of the Commission dated May 11, 2007 and October 9, 2007, disqualifying petitioner Edgar White Teves from running for the position of representative of the 3rd District of Negros Oriental, Arebers, and Zeta Side. Third, declaring that the crime committed by the petitioner did not involve moral turpitude. Under 250 provision letter F, no person has been convicted of a crime involving moral turpitude shall be eligible for election as a union officer or for appointment to any position in the union. It just means that Edgar Teves is eligible to run or to take an office or appointment because he did not committed any crime that is related or about involves moral turpitude.
The government has a priority list for its vaccine campaign. The country's 1.7 million frontline healthcare workers are at the top due to the high risk they face on a daily basis in the battle against the coronavirus. However, many elected officials and wealthier people have ignored those protocols since the country's immunization policy started. The DOH cautioned politicians to refrain from getting the shots reserved for health workers, and failure to do so might endanger the supply of COVID-19 vaccines, especially those donated by the World Health Organization COVAX facility. The DILG has issued show cause orders to those local officials for jumping the line in the government vaccination drive. Administrative cases will be filed with the Ombudsman Office against those alleged to have violated the procedures. According to DILG Undersecretary Dancing, they may face sanctions ranging from a 30-day suspension to removal from office. The Department of Health and its officers are obligated to inform everyone on the provisions and protocols to be followed. It is their duty as task health leaders to give operational guidance in the implementation of the COVID-19 vaccine deployment and vaccination program. By strictly securing and monitoring the vaccination program, the COVID vaccine will be received by the lined up members, and those who have been vaccinated illicitly or dishonestly without obeying the provided rules shall face the consequences. The corruption issues besieging PhilHealth have compromised the country's pandemic responses and undermined the much needed trust in public institutions amid the COVID 19 crisis. The situation gets worse with the new issues raised by former PhilHealth officials and employees. According to attorney Thorsten Keith, a former anti-fraud legal officer of PhilHealth, his investigation showed that 15 billion pesos have been stolen from the agency. He called the members of PhilHealth's executive committee who seemed to have been pocketing money from the corporation. The problem of corruption in PhilHealth, more than anything, victimizes the vulnerable, the sick, and poor Filipinos who are being cheated on medical assistance that could have been used to treat their illnesses and possibly save their lives. The funds of the PhilHealth shall be applied for purposes expressly provided by its laws. PhilHealth has thus far failed the people it's promised to serve. This is a major deficiency that needs to be addressed, and there should be accountability and transparency in PhilHealth's operations and decision-making processes. This current issue shows the importance of the rights and conditions of membership in organizations. For full and detailed reports of all financial transactions, every expenditure shall be evidenced, and other records of financial activities shall be open for inspection to spot any doubtful activities.